Hello, everyone. I guess we could begin. So tonight, we will start examining the topic on contracts. And so this is going to be an introduction. We're trying to cover some of the key theories that are associated with contracts law. And we will try to link that with how we understand contract law and what its importance might be in terms of what we do every day. But before I get into that, would there be anyone who might have any question before we proceed to do the tutorial? Would anyone have a question?
Yes, Manjo.
Yes.
I was looking ahead to go through to the semester planning assignment,
Yes.
and according to our schedule, this is week 2,
That's right.
but we'll be doing topic 1
Yes.
this week, and next week will be topic 2, etc.
Yes. That's right.
Just that when you get to topic 5, the following week after topic 5 is the break, but the dates now don't coincide because we started. This is now week 2, not week 1. So if you have a look at the break, it says we're going to break on the 14th to the 20th of December.
Yes.
According to my schedule, if we go down topic 1 this week and topic 2 next week, that is topic 5. So I think it needs to be pushed down a week, that break.
Which, you mean topic 5 should be after the term break? Is that what you were suggesting?
No. All I'm saying is the breaks.
Hold on. Is that coming from me? I wonder if that was my computer. It was probably mine. Okay. I'll have a look at that, and I'll try to get back to you by tomorrow, Peter. Would that be okay? Thank you. But thanks for pointing that out to me. Let's see. I'm just going to look at the chat if there might be any chat going on there. Okay. Okay. Anything else that anyone may wish to ask or raise? So I suppose everyone can hear me, and we could probably begin. Okay, so thank you, Chris. So for tonight, after studying this topic, you should then be able to describe in general terms the nature and purpose of contract law, and describe in general terms the classical promise and consent theories of contract law. But let's begin by asking the question, what do you suppose, I'm going to get back to you, Martin, in a short while. What do you suppose is the value of learning more about theories of contract law? Can I just get some discussion there? Why do you suppose is it important for us to kind of examine some of these theories of contract law? Are they valuable? Are they of any importance in our understanding of contract law? So if you could, I'd like everyone to post his or her answer in the chat box, and then we can take it from there, and then we will cover the first tutorial question. So before we address the first tutorial question, I would just like to have a short discussion of what we think is the importance of having an understanding of theories of contract law. So why is it important for us to know about theories of contract law? So can we just start, typing in the chat box? So we've got an answer from Tim. So I'm just trying to copy some of those which have been stated in the chat box. Now there's an interesting point here that was stated by at least two of you, and it has something to do with the use of theories as a framework for examining other wider issues. Can somebody try to explain that? Okay, so from Justin, give us a bit of a context. Okay, so real world is complex. Okay, can somebody try to take the floor and kind of explain what you think is the value of learning about theories of contract law? Can I get any volunteer there? When we speak of a theory, yes?
I can volunteer, it's Tim Begley.
Tim, yes, go ahead, Tim.
Just in very simple terms, that they serve as a reference point when dealing with practical situations, because there's no single. I said no single theory could apply to all situations. So they serve as a reference point for us to discuss and assess different situations.
Okay, thanks. But when we say that it serves as a reference point, what exactly do we mean by that?
I would say that they're the guidelines that we would follow when examining any particular case or issue. Multiple theories could apply to a single situation. But without these theories, where would we start?
Thanks. What exactly is the role of a theory in general? Whether or not we're speaking of contract law, or it could be a theory of criminal law or a theory of anything, theory of physics. What exactly is the role of a theory? And I like the idea here stated by Chris that theories are building blocks to build our knowledge. What exactly do we mean by that? So what exactly is the role of a theory? And there was a reference earlier to the real world being complex. And that is quite related to the idea of the importance of a theory. What does a theory do? So you've heard of the theory of relativity. What exactly is it? And why is it important in the first place? Any volunteers? Okay, they guide our opinions. They're a basis for learning. Okay, but how do they guide our opinions? They give us a basis of knowledge to understand information. Okay, good, Letitia. But how does a theory do that? How does a theory provide it?
They're accepted. They're accepted as truth or given. They're accepted as were generally accepted by all as the starting point for the truth.
Okay, we're getting closer. Martin, you made an interesting statement there. It's an attempt to explain or conceptualize something. What do we mean by that? it's an attempt to explain or conceptualize something?
I'm not quite sure. I guess it's you have the actual rules relating to contract or of any other type of law, but the theories try to encapsulate it and explain it and give a general wider perspective on the purpose of contract law and what it's trying to do, as opposed to individual rules.
Now, when you look at reality, or when you look at the real world, as somebody said, the real world is quite complex. And we try to find a way by which we could understand the real world by coming up with a simplified expression or a simplified illustration of what the reality is. So when you think of any theory, the role of any theory is to come up with a simplified version of reality. And by looking at that simplified version, you have a better understanding or a better sense of what reality is all about. Because if you try to explain reality as is, it's just too broad. There are too many key components of what reality is. But when you come up with a theory, you're looking for the key components of that theory, or if you might say, the key principles of that reality, and come up with something that is simpler. So that simple principle is an attempt to explain or to reconceptualize what reality is. So for example, when you speak of these various theories of contract law, these are actually attempts to explain in a very simplified format what the reasons might be that underlie the attempt by courts, for example, to come up with decisions in a particular way. And because a theory is by necessity a simplified version of the reality, it's difficult to come up with a theory that explains everything. So sometimes you can explain, a reason of a court based on, let's say, the classical theory. Sometimes you can explain it on the basis of a promise theory, or it could be the consent theory. It could be the empirical theory. It could even be the critical theory. So there are various ways by which reality is being explained. But when you therefore begin to understand the idea of what a theory is, you begin to make sense that the reason why a judge, for example, or a court is making a decision along these lines, it is because it is making an assumption about how a set of complex facts ought to be addressed by a common set of underlying principles. And that's what we'll attempt to do now when we try to examine the first tutorial question. Okay, would there be any questions about that so far before we proceed with the first tutorial question? None? So a theory is always a way to represent reality, which is complex, into something that is simpler, so that we capture the essence of reality by just looking at some of the core principles. And that's what, when you look at classical theory, or when you look at promise theory or consent theory, you see therefore some core principles that allow us to better understand why judges make decisions in certain ways. Because there is an underlying assumption, an underlying framework that is a way of addressing certain complex facts or issues. Okay, so let's begin with the first tutorial question. So which are the theories of contract law presented in this topic? And remember, there are many theories of contract law. And there are even those who argue that there is a death of contract law theory. But we'll just focus on some of the key ones. We've got the classical theory, the promise theory, and consent theory. Which do you suppose is the most persuasive for you as a layperson who is not yet trained in contract law, and why is this? And again, if you could, I'd like you to post your answers in the chat box. So please respond to this question. Which of the theories of contract law presented in this topic do you find most persuasive as a layperson not yet trained in contract law, and why is this? Okay, so we've got an answer from Letitia. If you could also explain why you think this particular theory is most persuasive to you. Okay, and what we're going to do after this is to try to examine the limitations of each theory. So we will then try to consider what exactly are the weaknesses of every theory, because every single theory always has its own set of weaknesses, mainly because, as we said, because it is an attempt to simplify what reality is, it necessarily means that it cannot possibly encapsulate or comprehend all the aspects of reality. Because if a theory were to attempt to represent every single aspect of reality, it won't be a theory. You're actually then describing the world. In the same manner that when you speak of a map is a simplified version of reality. But if you were trying to depict the real world, then you wouldn't have a map. You'd have, a colossal illustration that would then be an exact replication of what the world looks like. Okay, so can we get the answers there? So you've got some saying it's classical, some are saying it's consent. How about the others? Can I get the answers from the rest? Okay. How about the others? Jay, am I getting an answer from Jay? From Matthew, perhaps? William? So I've got an answer from Luke. Okay. Can somebody take the floor again this time and provide an explanation why you chose a specific theory as something that is persuasive? I particularly like the fact that Luke, for example, said that classical theory is the basis of contract law. I would be interested in trying to hear from Luke why he feels that classical theory is the basis of contract law.
Yeah, Dr. Manjo. I feel it's the basis because it just seems to me that all these other theories have actually progressed from this classical theory.
Mm-hmm.
It just seems like an original place to start. And since we are talking about foundations and frameworks and everything like that, it seems classical theory is a good place to start.
Okay. What is the, in a nutshell, what is the underlying assumption about the classical theory? What is its key assumption there?
I'm pretty sure it's that everything is pretty much black and white, very straightforward. It's either right or wrong.
Okay.
Which I guess is, just my sort of take on it.
Okay, thanks. What else? How about the others? What is the key assumption about classical theory?
I was going to say the basis of
freedom. Yep.
The basis of classical theory is essentially freedom to contract.
Yes, that's right. So the assumption is, people should be free to contract with each other. There should be autonomy of contract. And because we assume that people have a certain freedom to do what they want and to contract with whoever they want, then the role of the law is actually to avoid interfering with the exercise of that freedom. So let them negotiate. So the assumption is, parties are never, try to come up with an agreement with each other. It's something that they want to do voluntarily. And as much as they could, the law should attempt to avoid interfering with this specific freedom, the freedom to contract, the autonomy of parties. What's the problem with that kind of theory, if there is any?
It can lead to it. Sorry.
You're right. I was just going to say, like, people can be taken advantage of, I suppose, like weaker parties or less informed parties.
Right. That's right. So if you follow the idea of freedom of contract to its logical conclusion, it actually means that there is no need to protect anyone. So even those who might be taken advantage of, that's no longer the concern of the law. Because in the first place, they're simply exercising their freedom to contract. So that's one problem that we have. If you allow complete freedom of the parties to contract, you might be faced with a situation where somebody is vulnerable, maybe because of age or because of some mental constraints, or because of an attempt to constrain the exercise of his freedom because there's probably the use of duress or force or violence. So if we just look at it from the viewpoint of the freedom to enter into a contract without an attempt on the part of the law to get involved, then there is the danger that there may be certain persons that who need the protection of the law, who might then be at a disadvantage. So that's one problem. Anything else? What else? Do you really agree with the idea that there should be full freedom of contract? In other words, the law should never intervene or should not try to intervene. Leave it to the parties to negotiate with each other. Do you like that idea?
If there was equal knowledge and equal negotiating privilege or opportunities, then yes, but there's not. Okay.
Chris, did you want to say something?
Yeah, I was just going to say there might not be fair consideration given between the both parties.
Yeah. So if
and terms and conditions that people might put into the different things are just outrageous, I suppose, or unlawful maybe. I guess, yeah, that's where the law needs to step in when people just create crazy contracts.
Yeah, that's right. So if you just allow the parties to negotiate with each other, there is the possibility of some unfairness in the process. Unfairness in the sense that, although typically the law certainly will not intervene if one party may be at a disadvantage, that is never an excuse for the law to step in, but there might be certain circumstances when it may be too harsh if you allow the parties to just negotiate with each other, especially when the bargaining, for example, is really to the detriment of a person, for one, because there might be a lack of consideration, meaning, you know, somebody made a promise but doesn't get anything in return. Or it might be that there might have been no intention exactly on the part of a person to actually put himself in a situation where he becomes bound by what he promises. So in other words, in that case, the law may have to intervene. And in other words, there are certain public policy considerations that have to be considered when you examine the freedom of contract. So there will be times when, because of public policy, the law will have to step in. But there's actually another reason for that. Because although we say that the parties have a freedom to negotiate with each other, there's actually the possibility that the parties actually neglect to discuss certain crucial elements of the agreement. They may fail to talk about what the price might be. They may fail to talk about how a particular contract should be undertaken. They may have failed to discuss when certain goods that are the subject of a contract should be delivered. It may be that there are certain words that are being used in the contract that are vague or uncertain. In which case, in these instances, you obviously need the intervention of the courts. So in other words, if you leave it just to the parties they may not, in the end, agree as to what their agreement was really all about. Right? I mean, it's quite possible for people to have a misunderstanding. You talk to somebody, and then in a short while, you actually have a misunderstanding. And when you do, if you just leave it to the parties to resolve the issue between themselves, then you can see the limitation of the classical theory. There will be times when courts will have to intervene because there is a need to make sense of what the parties actually intended to agree on. Or it may be because it is necessary for the court to try to construe or understand what the legal effect really was in each of the parties' attempts to enter into a contract. Okay, questions on that subject before we move on to promise theory? None. Okay, let's move on. There were some of you, I think, who said that promise theory is persuasive. Can somebody explain why promise theory might appear to be more persuasive as a theory of contract law? Did anyone actually answer? Did anyone actually say that promise theory is the more persuasive theory among the three of the theories of contract law that we have started to discuss? Or at least could somebody explain what the promise theory is all about?
I think promise theory is the easiest one for a layperson to probably understand, because everyone at some stage in their life has made a promise to somebody else.
Yes.
To do something like to clean their room or to make their bed or whatever as a little kid. So everyone can really understand that, and that if you didn't clean your room, your mum might not give you the pocket money or whatever. Like, that's really basic understanding, I suppose. Yeah.
Yeah, and from Heidi, it's all about trust. If you make a promise, you must be able to trust that promise. And it is the role of contract law to make sure that promises are being enforced. It's part of a kind of a gentleman's code. Makes sense. Because at the end of the day, when you speak of contracts, is actually an exchange of promises. Somebody makes a promise, another one makes another promise. Without that exchange of promises, there's actually no contract. Or we might say that in the absence of an exchange of promises, there's actually a lack of consideration. Because somebody in that sense, without a mutual exchange of promises, you would then have a party who is promising to do something, but is not getting something in return. So there has to be that mutual exchange of promises, which is the basis of contract. Then I'm going to go back to the question of Martin in a short while. So that's what promise theory seems to be all about. What is the problem with promise theory, though? So if you examine case law, you will see that a common thread in many of these judicial decisions is the effort on the part of the courts to make sure that people to a contract comply with their promises. And it is the task of the courts to ensure the enforcement of promises that have been freely entered into. So that is the underlying assumption of promise theory. And so that if somebody breaches a promise or breaks a promise, there is a remedy that the courts can give, and this can be in the form of damages or an attempt at specific performance for one of the contracting parties to comply with a promise that he or she has duly made. However, what is the limitation with the promise theory? If you could identify one.
Some promises aren't meant to be legally binding.
Right. So that's the key point there. It's possible for you to make a promise. Let's say you promise a friend, oh, you can use my car or you can stay in my house. But actually, you have no intention there to be legally bound, which means that at some point you should be allowed to remove or withdraw the promise that you made. It could also be in the context of family relations, where a son may promise his father to take care of him even when, as soon as the father becomes really old and pay for all of his expenses. Again, the law realizes now that there are certain promises, as Martin pointed out, that are not meant to be legally binding, even though from a moral point of view, you may concede that there is a moral basis for the promise to be made from a moral viewpoint because of concerns of love or perhaps of morality. But actually, not every single promise that is made should have to become a legally binding promise. So promise theory also recognizes, therefore, that there are certain promises that are not intended to be the basis of a legal obligation. Now, moving on. Hold on. So let's look at the question of Martin. So if everybody is able to read the question of Martin, would it be fair to say that promise theory really originates from the birth of equity? Would anyone care to answer that question? In other words, the question of the thrust of the question of Martin, if I understand it correctly, is that is it necessary, for example, for us to consider the idea of equity when we speak of the promise theory? Are they necessarily related to each other? Or is it possible for us to consider the idea of the promise theory outside and apart of the notions of equity? And if necessary, we will need to define what we mean by equity as opposed to common law. Would the notions of equity and common law be clear to everyone? Or is that something that should be explained right now?
Manjo, I think that the two are like the overall idea of the morality and things like that of promises and equity, I suppose, in words themselves are probably related, but the two would be quite different, I think, because promises is really considering about what makes a contract and the consideration aspect, whereas I think equity is about relating it to like a fair and equitable outcome for all, because it originated from when they were having a lot of issues with people going through the courts and, not using the right wording or not, bringing the right papers and that sort of thing. And, the Court of Chancery or whatever was then created to make sure that the matters were held and it was run by churches rather than law people, just to make sure that people actually were getting fair outcomes, I guess, is a really basic first year law student understanding.
Which is quite good. So if you were to examine the distinction between the common law system as opposed to the system of equity, and then we will connect it to the question of Martin, how do we actually differentiate the two? Why, meaning, in other words, why did the notions of equity emerge? Why was there a need for the notions of equity to emerge? And why couldn't we just stick to the idea that there is a set of common law principles that can be the basis of judicial precedents, and that these judicial precedents are something that should consistently be followed by courts? Why should we speak of the notions of equity? Or what is the limitation of the common law system? There, from Martin. Okay, good. Thank you, Martin. So the common law system can be too harsh. So in other words, if you follow the common law system, because you speak of judicial precedents, you then derive certain core principles which you must prove and establish for the law to be applicable to your benefit. But sometimes, because these set of principles become too established, they then become rigid. In other words, it won't allow for an exception. So if, for example, your case will not is unable to show certain core elements that would then allow for the application of certain common law principles, then you've got a problem. Because then in that case, the common law system cannot help you because it is too rigid. In a sense, the common law principles are ossified. They are set in stone. Equity allows judges to, in a sense, come up with decisions that would suit the needs of the parties. It would allow judges to come up with decisions that may depart, in a sense, from common law principles, again, to suit the unique facts of a particular case. So in that case, therefore, the role of equity is to ameliorate the harshness of the common law system. The role of equity is to ensure that fairness and justice may actually be made available to the party litigants where the common law principles become too rigid and therefore may actually become a source of unfairness and injustice. So for example, if the common law system provides that for somebody to have to actually be able to be sued on the basis of debt, and that debt must actually be in written form, in the absence, therefore, of a paper document to prove the presence of a debt, then the debtor can then just say he doesn't have a debt. So the role, therefore, of equity is to ensure that in those circumstances where the common law principles cannot apply, then equity should be allowed to step in to suit the distinct needs and the unique needs of the parties in a case, so that fairness and justice can then be made available to the party litigants. Now, so going back to the question of Martin, would there be a need actually for the promise theory to actually be born or considered side by side with the notions of equity? Or can we actually look at the promise theory solely from the viewpoint of the common law principles and not from the viewpoint of equity? So for example, when we say that promises must be enforced, are we trying to derive or cite notions of justice and fairness in that instance? Or are we simply saying that, common law principles should actually protect the previous judicial decisions which recognize that promises have an obligatory character? Do you need equity for that? Or is it sufficient that you have core common law principles that do recognize that promises can actually be legally enforceable and that promises can be a source of law and a source of obligations? I guess we could leave it at that for now, unless somebody wants to pursue that point. Okay, so we could probably move on. Yep, you could answer either way from yes. Okay, thank you, Martin. Now, before we proceed with a discussion on consent theory, are we beginning to get a better appreciation of the role of theories of contract law in trying to understand the different judicial decisions concerning contracts? Are we beginning to see why theories might in fact be important and valuable in trying to understand certain cases that we will necessarily have to examine in greater detail in the weeks ahead? I hope that's going to be the case. So let's move on. In relation to the consent theory, would there be anyone who would be able to justify why you think that consent theory is actually a more persuasive theory of contract law? Or at the very least, can somebody begin by explaining to us what exactly is consent theory? And how different is it? Yes, and how different is it from classical theory?
So consent theory tries to identify rights and the transfer of those rights between parties, as opposed to a promise per se. I think the issue with that is, I think the benefit is that when you're trying to determine the intention of two parties, it's easier to assess what rights they were planning to give up or not. I would say the issue with it, though, is that some rights can't be given up, such as a prenuptial agreement, for example. No matter what a man and woman may, or any parties may agree to before marriage, that may not be enforceable under the law.
Mm. Okay, thank you, thank you, Tim. Again, when we speak of rights and that these rights can actually be freely traded, what is the limitation of the consent theory in that sense? What's the possible weakness of consent theory? Mm-hmm. I like the comment here by Martin. Okay. What's the problem with consent theory? And what exactly is the problem with the idea of rights in the first place?
Well, in Australia, I mean, there is no Bill of Rights. So what rights are we referring to?
Mm. When we speak of rights, for example, is it always possible to say that there is an objective understanding of what a right might be? Or in the end, is it a social construction? In other words, what we speak of as rights are actually concepts that we commonly agree that, this is a right. In other words, in some jurisdictions, in some countries, they may actually disagree on the notion of what a right is. So it's a social concept, as Amelia would point out. So if it is a social concept, what are we saying actually? Yeah, rights can differ between individuals. So it's a social construction. There is no such thing as an objective reality as a right. We agree what a right is because we agree on it. It's a social construction. It's based on an agreement by a community. So therefore, rights in that sense can actually differ between individuals, and it's quite likely that the way that one person views as a right the views of a person on what a right might be may actually differ from the views of another, especially of a person that may belong to a different jurisdiction or may belong to a different country based on certain social values or based on certain cultural practices. So from Letitia, whose rights is it to give up then? At the end of the day, when you look at contract law, there is an understanding that when two parties enter into a contract or try to exchange promises or try to enter into an agreement, both persons actually have certain rights. And the rights of one may be the right to have access to money. The right of another person may actually be the right to provide services. And so therefore they exchange some of their rights because they know that on their own there are limitations as to what they can do. And it will actually, we are all better off if we exchange rights with each other. So that's the idea behind the consent theory. As a society, we will all be better off if we end up exchanging some of our rights. So some of them, as Amira pointed out, one person mows the lawn in exchange for money. Or, so one may give up some of his time in exchange for money, or in exchange for some other form of service, or in exchange for a good. So we have certain rights that we each possess, and therefore we each have that ability to exchange our rights with the rights of another individual. But one thing we need to consider is that when we speak of rights, for example, these rights actually have a subjective dimension, in the sense that what might be a right to you or what might be of value to you might not be of value to another person. And we will see this later on from the viewpoint of what a consideration is. So when there's an exchange of promises, we always ask, what is the consideration for this promise, or what is the price for a person making a promise to another party? Now from Martin, where does the other get the money in the first place? Okay, we might be headed into economics in that case. What is the right worth? Yep. Okay. So can we move on and we'll move on to the next tutorial question, I think. Could I ask somebody to read the tutorial question 1.2 for us? Can somebody read tutorial question 1.2?
I'll read it if you want.
Yes, Chrissy.
Fundamental to our understanding of contract law is the question of whether a promise is the type of promise which should be enforced by law. Is this a reasonable question for us to be asking at all? For instance, would it be better for the law to simply enforce all contracts? Or perhaps the law should keep out of people's private arrangements and enforce no contracts? What rationale should the law have for choosing to enforce some contracts and not others?
Okay, so that's a set of questions there. Again, can I ask all of you to try to post your answers in the chat box in a few seconds, or when you're ready. Okay. How about the others? Okay, good. Okay, good. I'm getting some fantastic answers in the chat box. That's good. So it would appear that we're dealing with two extremes. On the one hand, there's the assumption that all contracts should be enforced. On the other, we're kind of saying that the courts should keep out of the private arrangements of individuals and shouldn't even attempt to get involved. Can you think of an example where it is actually right for the courts not to intervene with private arrangements and therefore not enforce a contract?
I believe contracts made between family members are at first glance deemed to not be intended to be legally binding anyway. So that would probably be my main example.
Because in that case, there was no desire on the part of any of the family members to be legally bound by any promises that were made. That's fine. But can you look at it from the viewpoint of a non-family context where you may have a contract where courts shouldn't bother intervening in the first place? Okay, there. I've got the answer here from Peter. I think that's the answer to my question. Peter, where's Peter now? Peter, would you care explaining to us your answer? Peter? Would Peter have an access to the mic there? Because I was hoping that, Peter, I was hoping for you to kind of elaborate on your answer because this is a very crucial point that you're making.
Well, I was just thinking that if every promise or every contract had to undergo legal scrutiny, it would mean the courts would be tied up in such minuscule or mundane contracts that nothing else would ever get done. The sheer number of contracts would outweigh the benefit, basically.
That's right. Thank you for that, Peter. And we will later on come across cases where the courts have pointed out that even if there's a disagreement between parties on the basis of a contract, it is actually not something that is a good practice for the courts to intervene in those circumstances where, for example, there is no issue about property rights, especially where what might just be involved will be a disagreement and a question of some embarrassment on the part of one of the parties, or maybe issues of pride. If every single time there's a disagreement between parties in relation to a contract, as Peter pointed out, the courts will be inundated because there's, the sheer amount of contract everywhere is just too much. Because remember, when we speak of contracts, we're not even speaking of written contracts all the time. There could be an oral contract which to an extent might be legally binding. But if we allow every single situation where the parties entered into a contractual relationship and the courts would have to intervene, the court system will be flooded by unnecessary cases. It's, as Peter pointed out, it's good for the legal fraternity, but not for the court system in general, because the dockets are going to be clogged. So,
Manjo,
yes.
I think as well, another point is that if you need to keep a working relationship with people that you've entered into this contract with, then it's also important to have other avenues rather than litigation, because of it's time consuming, it costs a lot of money, and generally, and also, yeah, as you said, like the pride of whoever loses is going to be shattered. So if you're, for example, if you're a property manager like I am, and you've got a tenant that you want to keep in the property, you want to go through your mediation steps and, conciliation, I suppose, first,
Yes.
and try to offer some bargaining there just to try and stop it from going to court, I suppose.
Thank you, Chrissy. You've actually raised a crucial point there, which I think can be linked to another theory which we should be considering, and that's the relation theory. Can somebody try to draw a connection between what Chrissy just said and the relation theory of contract law? Which again also is linked to the idea that not every single contract should require judicial intervention in terms of it having to be enforced. Can somebody try to draw a connection between what Chrissy said and the idea that courts should not always have to get involved every time there is a dispute in relation to a contract, by citing the relation theory? Can somebody try to do that? So from the viewpoint of the relational theory, can somebody try to explain, draw a connection between what Chrissy just said? And I'll go back to the point raised by Luke in a short while. Can anyone try to draw a connection between the relational theory and what Chrissy said about there being instances when you shouldn't have to go to the court system to kind of resolve disputes about contracts? Okay, based on an existing relationship. So what are we saying here? Latisha, how do we link that? So for Martin, some relationships and their disputes don't belong in courts. Yes. But actually, the other point we need to consider is that when people contract with each other, there's actually a set of relationships that override or kind of serve as a framework in which contractual relations are entered into. So as Chrissy pointed out, as a property manager, when she deals with a tenant, for example, or probably an owner of a property, or possibly a buyer of a property, there is a relationship involved that goes beyond the notions of a contract. And sometimes what it actually means is that when people enter into contracts or enter into agreements, they don't really look at the niceties of or the specifics of what contract law is all about. So in other words, when we go to a doctor to get, to be examined, or when we buy something, we're not really consciously thinking of contract law. Or do we? In fact, if you're not a lawyer, you don't know what contract law is. But you do certain things on the assumption that you could trust a person, on the assumption that there is a relationship that will be crucial in ensuring that you probably have a good that is of a standard or a quality that we know is deemed to be acceptable. So in other words, as far as contracts are concerned, contracts are not entered into solely on the basis of the framework of a law. More often than not, we enter into contracts on the basis of relationships, which means that sometimes we try to avoid getting the law in place. In fact, we try to avoid getting courts to get involved because it becomes more costly if every single dispute has to be resolved by the courts. We will be better off trying to resolve disputes about the contract, trying to complete certain aspects of the contract which might be vague or incomplete by having another discussion with the other party of a contract. Because if every time there is a dispute in a contract we bring it to the courts, that may not always lead to desirable results. Would you agree? And as Martin pointed out, suing people generally means the end of a relationship. Yes, so that's also from Michael. People can resolve things reasonably between one another in order to maintain a good existing relationship without going to the court. So in other words, when we therefore look at contract law, we need to examine contract law not just as a set of legal rules and a set of legal principles. Behind contract law is actually the idea that we enter into contracts because of a relationship, because you trust somebody. When you say trust somebody, you trust somebody that that person is going to be honest or that person can deliver on the contract. Because in the absence of that relationship, in the absence of a trust, imagine, you're a builder and you enter into a contract with, let's say, a subcontractor. Without the presence of a relationship or the presence of trust, you're actually opening yourself to the possibility that the subcontractor, for example, will fail to deliver on his side of the bargain, and then you're left with a major problem. And it may not be sufficient for you to just to get damages. Was that clear? So we need to understand, we need to look at contract law as going beyond a set of legal rules and principles. Because in fact, in truth, when we contract with one another, when we negotiate promises with one another, we are hardly cognizant or conscious of the legal framework of contract law. Truth? Would that be true?
I think contract law is all about, or contracts in general, is all about, cooperation with one another. And there was a little video, I don't know if you posted on this one or a different one, about the Sesame Street cooperation.
Yeah, that's right.
Fortunately, watched that one. But if, as you said before, if not everybody's can do everything by themselves, and you do have to enter into contracts to get everything done in everyday life, and they're always benefiting either yourself more in some situations or less in others, and there has to be a framework to know that you do trust the people, and that people know that there are ramifications if they don't go through with it. And that's where the theories, I suppose, come in for people to know.
Good. So it's 7 o'clock and it's about time for us to wrap up this tutorial. I've got a class at 7:15. Would there be any questions before we end tonight's tutorial? Comments, questions, anything you'd like to clarify? None? So thank you. And I'm going to be posting the legal memorandum assessment on Friday in Moodle, so you could start working on it. So, and I hope to see you next week. Thank you everyone for joining. Bye.